is Lisa Kirshner. I am the Public Access Ombudsman housed within the Office of the Attorney General. As I think many of you know, Spencer Dove is the administrator for my program, as well as providing support to the PIA Compliance Board. And joining us today is Sarah Clem, who serves as Assistant Attorney General to both programs. Today, we're going to focus in on and talk a little bit about discretionary privileges or exemptions generally, and then try to really hone in on the deliberative process privilege and some of its kin. So without further ado, let's move into the slideshow. So you've met us already. Great pics. Too bad I don't look like that anymore. Next. So this is a little outline of the topics we're going to cover. We're going to be jumping into the subject of exemptions, and more specifically discretionary exemptions, which are found in Part 4 of the Act. And most particularly, we're going to be discussing today the deliberative process privilege and attorney work product doctrine. They come into play under the Act under sections 343, which applies to all discretionary exemptions, and 4344. So we'll have a chance to talk about that. We've developed a few hypotheticals for us to bat around and exchange ideas. And then we will wind up by talking about what should be in a response letter if an agency decides to invoke a discretionary exemption, as well as what the remedies and enforcement are in case one disagrees with the assessment of the agency. And then lastly, we're going to give you some updates about what's going on in our shop. Yep. So, you know, when we do the PIA exemptions, we generally cover the whole, our PIA 101 training, we cover the whole gamut of exemptions. They come in a number of stripes and colors, primarily those that are mandatory and those that are discretionary. And then sometimes court orders can come into play and can also create situations where records have to be withheld. Today we're going to really laser in on the Part 4 exemptions, which relate to those set of exemptions that are to be exercised by agencies on a discretionary basis. Usually, when we give this training, we don't get to even mention the word exemptions until after we have covered some of the basics of the PIA and how it is intended to work. So to set the stage for our talk today about discretionary exemptions, I just want to kind of give you a thumbnail of that context. The Act is structured in such a way that the general rule is a rule of disclosure unless there is an exemption in the Act that either requires something to be withheld or permits it to be withheld. The Act does incorporate outside sources of law, whether they be state sources or federal sources, or whether they be common law doctrines, common law privileges. But the general rule is disclosure unless there's a legal source that says otherwise. The Act applies only to public records, a defined term, which encompasses anything made or received by an agency in the course of carrying out its official duty. Public records come in all forms and formats, and they can be located on devices anywhere. Devices in the office, in the physical office, in your home office, on the road. It's a very broad concept in that sense. So when we talk about exemptions, we have to understand that that is the backdrop. That is the backdrop in which these provisions are carving out from that general rule exceptions, some of which are mandatory, some of which are only permissive.
I'm good. Yeah.
Okay. So, you know, discretionary exemptions, I think, are best understood by comparing them to the mandatory ones. So when you have a mandatory exemption, there's really only one consideration, and that is, does the record or the part of the record fall within the ambit of that mandatory exemption? And if the answer to that question is yes, then the law is commanding the agency to withhold it. There's no choice involved. If it applies, it is withheld. You can think of that as kind of like the commandments. Discretionary exemptions, in my mind, are a lot harder and trickier because the legislature, in crafting discretionary exemptions, has directed the agencies not to apply a hard and fast, rigid rule, but to consider on a case-by-case basis whether records or parts of records should be withheld for the reasons specified in this class of exemptions. It's really a more complicated process, and you have to go through at least two steps, one of which is the familiar one of figuring out if an exemption applies. But once you figure out it does apply or is eligible to be applied, you have to then go on and ask, should it be withheld? Because I have permission to release it, the legislature is giving me permission to release it. The question is, should it? And the should it part is generally addressed by section 343, which applies to all Part 4 exemptions, and basically requires you, after you've decided that a particular discretionary exemption applies or could apply, you have to further determine whether the balance of interest weighs in favor of withholding it, meaning would release of this record or this material be contrary to the public interest. Public interest, of course, is a very, very broad concept, and hence the reason I say these exemptions are, in my mind, they're a lot trickier and need to be applied in a very careful and considered way. Two of the aspects of discretionary exemptions we're going to consider include something called the attorney work product privilege. Lawyers are very familiar with this. It pertains to materials they produce in certain circumstances. And the deliberative process privilege, which is a constant source of frustration, anxiety, uncertainty, and consternation, I find, among both requesters and agencies, and I hope we're going to explore and discuss some of the reasons for that in this discussion. Both of those doctrines come into play under section 3-44 of the Act, which has the title of applying to inter and intra-agency correspondence and memos. So we're going to try to delve into that and unpack that a little bit. One of the features of discretionary exemptions, that would be all of the Part 4 exemptions, is that the custodian should always consider whether, even if an exemption applies to some portion of a record, is there any portion that can be released? So again, this is another reason these exemptions call for very careful consideration and review on a case-by-case, page-by-page basis. We can go to the next illustration. So we're going to jump right into inter or intra-agency letters or memoranda, which incorporates the deliberative process privilege. I always like to start with, when considering a privilege, its purpose. And the fundamental purpose of the deliberative process privilege is to protect the decision-making process that agencies go through, in the course of carrying out their official work. So what's highlighted in yellow here are really some of the most important features of this privilege. First of all, it is protective of certain pre-decisional deliberations and deliberative material if disclosure of that material would harm the decision-making process. It can be invoked, it can apply to decision makers who are both high and low, right, on the agency hierarchy. it can generally covers opinions and advice and other types of deliberative content, not merely kind of factual recitation of the who, what, where, when, and why of things. And then, as noted, it also covers something known as the attorney work product doctrine. We'll talk about that in a little more depth. So, yeah, this is the part I like. 343, as I mentioned, applies to all discretionary exemptions, and I think of it as the second step in the analysis whenever you're going to considering whether a discretionary exemption should be invoked. It's the second part. If it applies, then you have to go on and consider whether the public interest weighs in favor of withholding the material that's covered by that exemption. I love the wording of section 4344. It is something that in my work as ombudsman, I'm constantly trying to help unpack, particularly for requesters who may not be versed in the doctrines. But it applies to any part of an interagency or intra-agency letter or memorandum that would not be available by law to a private party in litigation with the unit. So I don't know how many people who have come across that have wondered and really scratched their head as to what the heck that means. What does it mean to say it wouldn't be available to a private party in litigation, and what does that have to do with my record request? But it is part of the reason this exemption is I find is a constant source of frustration with requests that are being denied under it. It's not at all intuitive, particularly for lay people, as to why inter or intra-agency communications would not be available to them. And I think part of that is because the fundamental purpose of the Public Information Act is to facilitate our participatory democracy, which requires an informed citizenry. How do people become informed about what their government is doing? Well, one of the ways is to go look at the records that show what they're doing, that shows what they're thinking about, shows what they're considering. And so how can this be protected? This is what the whole act exists for. So this is, there's a very direct tension, I think, between the purpose of the Public Information Act and this discretionary doctrine, and it has to be very carefully balanced, I think, if it is going to work as intended. We can have the next slide. So, you know, because this is a discretionary privilege, there's never going to be a right and a wrong answer. There's never going to be a formula. You know, I go through steps A, B, and C, and that gives me the answer. It's always going to be a balancing, but a helpful framework, I think, could be when considering any particular document or communication, inter or intra-agency, is to ask yourself, is there content in this document that relates to a decision in process? And in that sense, is it pre-decisional? Second important consideration, second ingredient is there content in this document that not only is it relate to the decision-making process itself prior to the decision being made, but is it deliberative in nature? That is there some discussion of pros and cons, the ups and downs, the vetting of scenarios, and that sort of thing? If the answer to both of those questions is yes, and again, I would caution you have to look at the precise content and determine what is pre-decisional about it, what is deliberative about it. But as to that content, you then have a document that would be eligible for withholding, or that part of the document would be eligible for withholding under the deliberative process privilege as it is incorporated in the Act under Section 4344. That leads you to your second stage. Should I, now that I know I can withhold it, should I withhold it? does the public interest weigh in favor of withholding, or does the balance of the public interest weigh in favor of disclosure? I can have the next slide. Okay. So why are these two ingredients so important to the deliberative process privilege? The fundamental reason is that its purpose is to protect the integrity of the decision-making process, and it reflects a value judgment that it is very important to our democratic process for decisions, governmental decisions that have to be made, to get the best possible vetting and to create a space where that vetting can take place, free of all kinds of other concerns, free of concerns about accusations or retribution or all kinds of things that can lead to a chilling effect on candid debate. Privilege reflects a judgment that it's most critical to protect that vetting while the vetting is going on, not after the fact. Once the decision is made, generally these decisions are unless some other privilege applies to them, they're going to be public. And so once the decision is made, the law has typically viewed it as less important, less critical to protect what may be said about a particular decision or the reasons for it.
And Lisa, if I could just jump in really quick,
Sure.
I think to stress that, communications may still continue to be protected even after the decision is made, right? Like what the analysis is, where were we in the process of making the decision when this communication was made? It's not just, once the decision is made, then everything that was said about it previously suddenly becomes subject to disclosure.
Thanks, Sarah. That's absolutely right, and there are many situations where that will come into play. So next slide. Opinions and advice versus facts. So this is a distinction that really goes right to the kind of the point that whenever you're considering a discretionary privilege, you have to examine whether any part of the record is disclosable. That is, whether the record can be produced in redacted form or not. And in this regard, what this privilege protects, generally speaking, are things that are in the nature of opinions and advice and the vetting of opinions and advice, as opposed to, what I'll call bare facts now, or raw facts. Sometimes it's hard to distinguish those two, and sometimes they may be very intertwined in the content of a document. So that's a judgment that has to be made on a case-by-case basis, but oftentimes you'll find that there will be content within a document that contains factual background, a recitation of the relevant history. And typically that is not, may not come into play, may not be part of this privilege. Again, it's a very nuanced kind of judgment that has to be made and has to be done on a case-by-case basis. Next. Okay, so this is a quote from the PIA manual, which I know most of you are familiar with. You can see in the lower right-hand corner of this slide, there's a little icon relating to the manual and a link that will take you right to this reference. But it's a good suggestion, as I think, as a framework for approach, that a presumption of disclosure should, this is a quote from the case that's cited here, a presumption of disclosure should prevail unless the responsible agency official can demonstrate specific reasons why agency decision-making may be compromised if the question records are released. An agency should determine whether disclosure of the requested information would actually inhibit candor in the decision-making process if made available to the public. So I think what this quote is getting at is that there should be some definiteness to the conclusion that the decision-making would be harmed by release. That is, you can trace actual reasons to think this actually would occur, as opposed to a merely theoretical possibility that if opinions were released, that it would be harmful. Again, this is a very nuanced type of judgment, and it requires a lot of care and sensitivity in making that call. One of the risks is that if that kind of care is not exercised in applying this privilege, this particular privilege, in my view, has the potential to be the exception that swallows the rule. And it's for the very reason I mentioned earlier. It's because there's a kind of an almost direct tension between this privilege and the underlying purpose of the Public Information Act, to have an informed public, to facilitate a participatory democracy when it matters in the decision-making process, versus protecting that process itself and protecting and encouraging people to be absolutely candid in vetting decisions. So that is a very, very tough, in my opinion, a very tough balancing act. And that's why custodians, I think, and all involved in the process need to try to take a lot of care in the application of this privilege. So this brings us to another doctrine that comes into play under 4344, and I'm going to turn this one over to Sarah.
Sure. So the attorney work product doctrine, this is a doctrine I think that's a little bit more obviously related to the language of 4344, in that, you know, typically work product generated by an attorney isn't going to be something that you would have to hand over to your opposing counsel or your opponent when you're litigating something in court. So the doctrine protects work that a lawyer produces in anticipation of litigation or in readiness for trial. It does not protect material that a lawyer may prepare in the ordinary course of business. And there was a recent Court of Special Appeals, I guess now called the Appellate Court of Maryland, case that involved the do not call list of police officers that the Baltimore City State's Attorney believed had integrity issues that would prevent them from being called to testify in cases. So it was this list of officers. I think that was circulated internally within the office to make their attorneys aware that these officers had issues that may either, you know, again, prevent them from being called, or that they may have issues that they have to disclose to defense counsel under sort of the rules and the Constitution. And the court actually held that that was not protected by the work product doctrine. You know, it said that the mere fact that the office, you know, a state's attorney's office, is in the business of routinely engaging in litigation doesn't mean that everything that they prepare with regard to that sort of general circumstance is going to be protected work product. You know, I think this particular decision is generated a little bit of controversy. I think, you know, the court's language is pretty broad, but I think sort of the point that they're trying to get at there is that, you know, just because you are in a setting that is always engaging in litigation or most always engaging in litigation, it doesn't mean that every record you produce is going to be subject to the privilege, even a record that may actually be used from time to time. You know, this list was maybe more fairly viewed as sort of, you know, a notice of office-wide policy with regards to certain officers. You know, so I think it's just something to sort of to keep in mind that, you know, I think when it applies, and this is, I think, addressed on the next slide, but when it applies, I think courts are very reluctant to question a custodian's withholding under the doctrine, but that you do need to look carefully at what it is, that's being requested to see if it fits within the parameters. And again, withholding under 4344 is discretionary. So the calculus is whether disclosure would be contrary to the public interest. But as I just said, I think that the quote from the case is that it would be at best difficult to say that an agency's decision to withhold was contrary to the public interest once the court does determine that, yes, this is attorney work product. And I would just note too, it's sort of related in a certain way to the attorney-client privilege, which is another privilege that I'm sure most of you are familiar with, but there are differences. Again, this is a discretionary exemption, whereas the attorney-client privilege comes in under 4301, which is a mandatory exemption. So unless the privilege is waived, a custodian cannot release records that are protected by the attorney-client privilege. And you could see there could be some circumstances where work product might have attorney-client privileged information in it that would have to be redacted if for some reason it was going to be released. So that's just something to kind of keep in mind when you're faced with questions related to the attorney-client privilege as well. All right, so now we do have
Sarah, we have if I just jump in, we have a question. Is there a threshold in Maryland for determining public interest? Which is an interesting question. I think the answer is no, in the sense, if the question, I invite comment on this, but there's no formulaic test that defines public interest. There are, one finds in the case law, factors that frequently come into play in determining public interest. And in the PIA context, for example, things that are closely tied to the purpose of the PIA can be considered. This comes up all the time in the fee waiver context, which waivers can be granted simply on the basis of being in the public interest. And one of the factors that one can consider there is whether this, granting the waiver would encourage wider dissemination of the material, the information, in a way that's consistent with the PIA. But to answer your question, I don't know that there is a threshold or any kind of hard and fast rule for determining public interest. It's one of the things that make its application so difficult. I don't know. What do you think, Sarah?
Yeah, I agree completely. I think it is very case by case. I mean, obviously, a custodian has to do more than just simply say that disclosure is contrary to the public interest. There has to be an explanation about why and what that, how the public interest, may be harmed or negatively affected. But I do think it is very case by case.
One of the, I'm just going to jump in with this. One of the hardest parts, I think, about discretionary exemptions and the privileges that we're talking about in particular are that by their mere existence, their existence in the law, whether they've originated from a court, a judicial doctrine, and then are incorporated in the act, through these statutory provisions, there has already been a determination that these privileges do serve a public interest. On the other hand, it is also true that they are exceptions to the general rule that the Public Information Act provides, which is the general rule of disclosure. So it is also true that disclosure is almost the default rule, and there has been kind of a sweeping judgment made that disclosure should be the general rule, and is in cases of doubt, err on the side of disclosure, at least in the area of discretionary exemptions. I think that's the case.
I would also just note, there are a handful of discretionary exemptions where I think there is a little bit more explicit guidance about the public interest written into the exemptions themselves. I'm thinking in particular about 4351, which covers certain law enforcement agency records. There are a list of 7 different reasons why a custodian could deny inspection to a person in interest. That's the person who the record is about. So their burden is a little bit higher in those circumstances, but there's been a lot of, both guidance and case law that suggests that those factors, those 7 factors, are also kind of indicative of what, maybe what might be contrary to the public interest, just generally. And then 4352, which is the exemption that deals with sort of security and infrastructure related records, like it was passed in the wake of 9/11, so it was sort of focused on emergency preparedness and things of that nature. That that exemption also lists very specific harms that a custodian has to consider and determine whether disclosure would cause one of those harms. So endangering the life or safety of an individual. And on a certain level, I think those are pretty obvious instances in which disclosure would be contrary to the public interest. It would cause a pretty significant harm. But those are in there, I think, to consider.
So before moving on to our hypotheticals, I put in the chat, just in case our friends on the phone or others can't see it. We're coming to a point where we're going to pose 3 hypotheticals and ask for a level of interaction. But if you have any questions about what's already been covered, I think we have a couple of minutes right now to take those questions. So feel free to ask us.
No questions.
All right. Well, I will go ahead.
Okay, so we have, I think, 3 hypotheticals. I'm going to run through the first one and the third one, and Lisa's going to take the second one. And I guess before we delve too deeply into them, I just want to give a general caveat that these are really meant to help you just sort of think through how to apply this exemption generally. It's not necessarily, slight tweaks to the hypothetical could lead you to a different outcome. So it is meant to be sort of generalized and just kind of sort of broad brush helping you think through the analysis. So the first hypothetical is you've received a PIA request, and one of the responsive records is a draft letter regarding a position on legislation, like an agency's position. And so in that draft letter, there are comments by employees in the margins that are offering reasons why the agency should support or oppose the measure. And the draft letter also contains factual material about the agency's budget, the agency's staffing and resources. So the first thing you want to ask is this pre-decisional? You're going to go through the sort of 2 threshold requirements that you'd have to meet. And I guess, does anyone want to maybe weigh in the chat as to what they think, whether this is a pre-decisional? Actually, Spencer, it looks like the chat is muted. I don't know.
Chat is what?
Muted. Although I guess we did get a question earlier. Okay, yeah. So someone has said pre-decisional. So Spencer, if you want to.
Anybody else?
Yeah. Yes, it is. Clearly, right. The decision to be made is the agency's position on the legislation. So it is pre-decisional. The next question is whether this is deliberative in nature. And I think, again, it's pretty clear that it is deliberative in nature, at least to some extent. Yeah. So the comments by the employees would certainly qualify if their opinions or advice about what position to take, which they are. And even the draft position at issue may also qualify because it's still being considered, it's still being vetted. However, the factual material that is in the draft letter may be disclosable. It may not be subject to the privilege. again, you know, as Lisa mentioned earlier, there are certainly instances when factual material is very intertwined with the confidential opinions and advice that are being offered. But, you know, to the extent that you can redact it, just to leave that purely factual material there that doesn't reveal any, you know, anyone's position or thinking on the issue, then that should be disclosed. So my sense is that in this particular hypothetical, the information about the agency's budget, its staffing, its resources, that information would likely be subject to disclosure. And so then once you've answered these questions, you go kind of to the bottom line, you know, that you have a document that is subject to the privilege or subject to 344. So the question is disclosure contrary to the public interest? And, you know, I think if the custodian here would be able to point to specific reasons why decision-making is likely to be negatively affected by disclosing this letter, then, you know, I think it would be an appropriate exercise of discretion to redact out those portions that would be contrary to the public interest in that way.
Sarah, we have an interesting question in the chat. Wouldn't it matter who the comments were directed to?
I mean, I guess it could. I mean, assuming they were directed to whomever it was that drafted, you know, whichever agency official drafted the letter, they're offered to. These an inter agency, I suppose, communication, right, from one agency employee, and it could be to another employee of equal standing. It could be to an employee who is a supervisor, or even, you know, maybe the agency head who has circulated this letter.
What if, Sarah, I mean, we've all had the experience of sometimes reading something and we make marginal notes while we're reading. It's almost like we're just crystallizing our own thoughts. Maybe we end up expressing them in a meeting later on, or relaying them, or refining them at some point. But I mean, I do that all the time. I just make marginal notes on things. Would that be subject to withholding in that circumstance? Notes to myself that are kind of my internal thought process while I'm trying to digest something? Assuming I'm in the decision.
Yeah, I mean, I don't know that that's
making pool.
Yeah, I mean, I that's a good question. You know, I think in that sense, it's sort of like internally deliberative and not as between. Right. I mean, again, I think you just go back to the question of like the decision-making process, and really focus on, is that going to harm, like, releasing my notes? Is that going to harm the decision-making process in some way? Because I think, you know, the privilege is, again, and it's designed to encourage this sort of candid exchange of thoughts and ideas, and so that people feel completely free to offer their candid advice and not to temper it in some way. And so, you know, if you don't think, if that's not going to be an issue with releasing your sort of internal thoughts, at least, you know, under this exemption, the deliberative process privilege. I'm not sure.
It might also matter if I'm in if the note maker is in the decision making, as part of the decision making process.
Mm-hmm. Yes.
You know, I may make notes or comments about all kinds of things that I have no say in whatsoever, and I don't think they become subject to this privilege just because they reflect my internal thoughts about it.
Yes.
Right. But if I'm in I'm in the mix and I'm kind of formulating maybe my comments, I would think that would make them eligible for consideration under this privilege.
Yes. Yeah. And then the question again is what harm to the decision-making process, if any, would come from disclosure?
They might be completely inconsequential.
Mm-hmm.
Right.
Any other questions before we move on?
Actually, Spencer, if I could just interject really quick, I think to that last question about, you know, mattering who the comments were directed to, you know, I think it is important to just keep in mind that the deliberative process privilege is related to but distinct from a different privilege, which is known as the executive privilege. And that is, that comes from sort of the Nixon line of cases from the Supreme Court, with this idea that, an executive, so the president or the governor, needs to have to receive candid, frank advice from people who work for him or her, right? And so we protect those communications to the executive in the interest of the integrity and the quality of that kind of advice. I think there's an AG opinion about the governor receiving advice about the budget and his duty to come up with a budget, and how he needs candid advice about those sorts of issues when carrying out that duty. And so, but the executive privilege is different. I mean, it comes into play under 4301, which again is a mandatory exemption, so that, unless it's been waived, a custodian would have to withhold under the executive privilege. But there, I think it does matter a little bit more who the comments are directed to. I think it's the Stromberg case in Maryland that talks about the deliberative or the executive privilege, isn't really designed for sort of those lower level employees, right? It really is concerned with the kind of top executive and his or her sort of close network of people that are there to advise and offer opinions and things of that nature.
That's a good point. Okay, this brings us to our second hypothetical. So in this hypothetical situation, you receive a PIA request that calls for production of an email that's been circulated internally within your office following a press conference that announces some agency decision or action. And in this email, the author is offering opinions that are critical of the agency's decision. So what are we going to do with this one? So following our framework, our proposed framework, first question is this content pre-decisional? Does it relate to a decision that has not yet been made? Right, I agree. I think that this email does not relate to something that has not, some decision that has not yet been made. Under the assumptions of the hypothetical, the decision has not only been made, it's been publicly announced at the press conference. So that element is not satisfied. Next question in our framework is it deliberative? Does this email have deliberative content? Is it offering opinions and advice? How to change things moving forward? I would suggest, in theory, somebody could speculate and say this was a bum decision, and I sure hope the agency considers an alternative in the future. But in my mind, the question would be, is there really presently an open decision-making process going on, not merely whether a particular individual or group of individuals think that the agency should have made a different decision and are expressing that. That's kind of my own take on that. That deliberative process, when we say pre-decisional, we're talking about an actual decision-making process that is either in play at that time or is on the near horizon, something rather that can be defined and articulated with some specificity. Is it deliberative? And yes, under our situational hypothesis, yes, it does contain opinions, views, value judgments about the decision that was made. It is deliberative. And so with those two answers in mind, is this going to be a disclosable email in whole or in part? Again, we're just looking, we're only considering this in the context right at the moment of section 4344. In real life, custodians have a much harder job because they have to consider other depending on the content, they have to consider a wider range of possibilities. But for the moment, we're just focusing in on 4344. You see, this is the tension. This is the tension in this. I think this is a good hypothetical because it really kind of brings to the fore kind of the gut wrench. One feels a little kind of pulled in both directions. Why should somebody's personal views or professional views about something that have been written about isn't that what we want to encourage? Amy, I come out on this one the way you do. If it's not pre-decisional, it's not eligible for withholding under this particular privilege. Even though it contains opinions, it's not pre-decisional. It's not part of a decision-making process. Again, remembering the purpose of this privilege is to protect an actual decision-making process, either then in play or that is on the near horizon and has some kind of definition to it. I think that is the right answer in this case, that it gets produced, assuming no other exemption applies. And that will take us, I think, to number 3.
So this one I think is a little gnarlier potentially. So this, you've gotten a PIA request, and one of the responsive records is another email chain. And this is about an agency, say the agency head or a deputy is feeling inclined to extend a deadline. So they received a request to extend a deadline for a project that's gotten a lot of interest from the public. It's gotten a lot of press attention. It's sort of on everyone's radar. And the communications in this email chain tend to detail reasons why the employees of the agency would support it, why they think it would be a good idea to extend the deadline. And so ultimately, the agency does decide to extend this deadline. And when sort of explaining that decision, they cite many of the reasons that are contained within that email chain. So again, going to our first question, is it pre-decisional? And again, what we're talking about is it pre-decisional at the time that the record was created? So at the time the record's created, the decision hasn't been announced or made. I guess I've just given the answer. Why haven't I? Is it pre-decisional? So yes, it is. They're exchanged before the deadline. So the next question, which I think is whether or not the record would be deliberative in nature. And yes, I do think it is. I mean, it's the agency is wrestling with should we extend this deadline, and the employees are offering their opinions and advice in favor of doing so. Even if everyone agrees, it doesn't mean that it's not deliberative. And so then we turn to our question about the public interest, whether releasing this document that is eligible for withholding under the exemption, whether releasing it would be contrary to the public interest. And does anyone have thoughts on that question? So I guess, I mean, I can just say here, I think this is a pretty sort of a tougher call. Yeah. So Amy said not contrary to the public interest since the reasons were given. The prerequisites of the exemption are pretty clearly satisfied, but to me anyway, it wouldn't be clear that disclosure would be contrary to the public interest. It's an issue that's of public concern. The public is interested in, so the interest in disclosure is arguably pretty high, and the agency had cited publicly at least some of those reasons, right? And so again, there's this idea that the public is interested in knowing the reasons that supply an agency's decision. But again, at the bottom line, the question again is about sort of harm to the decision-making process. And it's not clear, at least with the hypothetical, that would be there. So the question is, if there was some supporting and some opposed to extension, would it be different? I think that would inject maybe a little more gray area into it. Again, it's focused on encouraging like sort of free and frank advice and opinions of the people who are involved in vetting a decision. And so, to the extent that right, or someone who's kind of higher up the chain than them, you do want to get your best decisions, you may want dissent. And so I guess the question would be if disclosure might harm that aspect of it.
So
Lisa, do you have it? Yeah,
jump in, Sarah. One of the earlier slides referred to a case cited in the manual that said that in general you should have specific reasons for thinking it would harm the process. And so the question I would ask, Mary, is an agency debate, internal debate or an intra-agency debate about extending a deadline, pro and con, is disclosure of that debate likely to harm that decision-making process? I think it's not clear to me that debating whether or not to extend a deadline, even if there's disagreement about it, is going to chill the debate. On the other hand, one can envision other situations where internal debate might be far more sensitive. So I think, again, that's really something you really have to be very attuned to on a case-by-case basis. And then Kathy's asking, so because it's not contrary to public interest, the email would be released. I mean, my view, that's part of the balancing of interest. Which way does the public interest weigh? What is the balance of interest in favor of disclosure or against it? That's the judgment call. If you think that disclosure would not harm the process, or you can't articulate some specific reasons to think it would harm the process, then it's disclosable. Then I think that's the discretionary call. Sorry, Sarah.
I was going to say it's disclosable under 344, right? You could imagine other sort of facts injected into this, right? Where maybe some of it's attorney-client privileged, or something like that, right? But under 344, I think this would be releasable.
And so Chris has asked the question: isn't this decision the discretion of the agency? So while you may have a different view when the agency's decision control, I think the answer is the exercise of discretion means the reasoned and principled reaching of a conclusion. And so if the agency goes through that process and answers, it is pre-decisional, it is deliberative, and weighs wherein the balance of public interest lies, that sounds to me like an appropriate exercise of discretion, as opposed to, for example, saying it's pre-decisional, it's deliberative, and I'm going to withhold the whole thing, even the non-pre-decisional and non-deliberative content, or it's pre-decisional, it's deliberative, and therefore I will withhold it. I will withhold that content without consideration of the balance of interest. That is not the exercise, in my view, that's not the exercise of discretion. That's applying an automatic rule that if it's pre-decisional and deliberative, we withhold. But I think, yes, if an agency goes through the proper exercise of discretion, absolutely, there's a high degree of deference to the agency's decision. But that's the key. They must go through the proper exercise of discretion. And that's sometimes very hard to do in the press of business. It just happens. People are busy, understaffed, under-resourced, and it's much easier it's much easier to just go to the automatic default rule. And it happens. That's why I say discretionary exemptions are so much harder than and more complicated than the mandatory ones, in my opinion. They're harder. I don't know if we're having some technical problems here. Sarah, your screen is freezing on me.
Ooh, can you hear me?
Now I can hear you. Yep, now I can hear you. Maybe it's
fine
just
on my end. It might be our OAG network since you both are in the office, but everything's okay as far as I can see from afar.
Great. Yeah, I think our member attendees are really hitting on some of the really important questions and hard parts of this particular privilege. It's hard.
Jay also posed a question about deteriorating public trust in the chat.
Well, I'm sorry, could deterioration of public trust in an agency be considered contrary to public interest? If I'm understanding this question correctly, I think yes. In other words, could an agency properly consider, when it's doing its public interest analysis, could it properly consider whether disclosure will encourage and support trust, public trust in the agency, when withholding might have the opposite effect? Is that a proper consideration? I think that is an appropriate consideration. And I think one of the areas where we've recently seen that come into play in quite a public way and definite way is under Section 4351, which pertains to investigative records, and the high public interest and intense public interest in understanding how law enforcement agencies are doing their job, and so. It seems to me that, for example, in enacting Anton's law, the legislature, and moving, Sarah, feel free to jump in. I'm no expert in this area, but it just, you know, my read of it is that the legislature recognized that certain types of records that had been in the past withheld automatically on a mandatory basis, that there was such public interest in having having much of this information available to the public shifted internal affairs records over to the discretionary exemption or eligible for consideration under the discretionary investigative exemption. I didn't say that very well, but to answer your question, I think that's a very appropriate consideration. I think we've seen it play out in that one arena in quite a public way. Communications used to be more verbal, but now most are held over email. Are emails allowed to be deleted and therefore not available for PIA requests? I think the question, first of all, not just because an email has been deleted, as I think many of you know, doesn't mean they are gone from the system and are no longer in the custody of the agency. But that's a different question. Whether a record is in the custody or not is a somewhat different question. I think your question is really implicating a number of different arenas. One is the custody arena. Another, I think, is the record retention arena, which is governed by different statutes and in some cases regulations. And how long and in what form agencies are required to maintain records generally is a record retention question, not a PIA question. Record retention is vitally important to how the PIA works, but the PIA itself does not govern it. And then last but not least, I think your question is also getting to a bigger point, which is, should all many agency communications, maybe most of them nowadays, are held by email, but is that a wise or prudent practice? Is email the best format for discussions? And I think that is a very fair question to ask, and that agency staff and counsel should be considering. I personally, in many cases, prefer the old-fashioned way of, picking up the phone and talking to people, or walking over, and when we're in person, going into somebody's office and having a conversation. Mostly because I find I can do more faster that way, actually. But then I'm from the pre-digital generation. Laura says, if an agency determined that a record was pre-decisional, deliberative, and its release would be contrary to the public interest, and the requester later files a complaint with the PIACB, would the board support the agency's determination? How does an agency prove its case? Sarah, that one's in your bailiwick, not mine.
Yeah, I'm afraid I mean, I can't really, I can't answer a question that's that generalized, right? I mean, the board looks at each case that comes before it and the arguments and the submissions that each, the custodian and the requester provide. So I mean, I can say that if, as Lisa was saying, right, like if the agency goes through the proper analysis and is able to support its, and show that it was a reasoned decision, I think that the case law suggests that the agency's determination is to be upheld, even if a court might disagree or come out differently. But again, that is a case by case basis, and I do not have an example of a determination that was overturned, at least not from the board.
Has the board had any case yet, published any opinions yet, Sarah, that dealt with 4344?
There was a decision that dealt not with 344. There was one that had two discretionary exemptions. One was 4351, which again is like the law enforcement related records, and then the other exemption claimed was 4352, which I had mentioned earlier. Does have sort of that heightened level of showing that that disclosure is contrary to the public interest, and the board determined that the custodian had not met its burden under that exemption, the 4352, but that it had under 4351. But the board has not had a case with 4344 yet.
I think the hardest part. Yeah, I'm sorry. I didn't mean.
Oh no.
I was just, this is kind of maybe indirectly related to Laura's question, but in my mind, one of the hardest parts about this whole deliberative process arena is that the purpose is to protect the decision-making process. And in order for this privilege to operate as intended without totally gutting the PIA, right, and swallowing up the general rule, it has to be applied with really some very really terrific care and consideration that I think requires a good deal of self-scrutiny by agencies and their counsel as to whether disclosure really would hurt the decision-making process. And in order to go through that, I mean, I think that requires a great deal of self-scrutiny or the capacity for that. And then in reaching if the agency reaches the conclusion that it would, that my suggestion would be the agency should be prepared to articulate why exactly that is. And then they have to balance that against the interest in disclosure. And why do I say that? I say that because the greatest public interest in disclosure is going to come up around the most consequential decisions. And sometimes those decisions are quite controversial. And so that's where it's both most important, in my view, it's most important to protect the decision-making process, but it's also where there is the greatest public interest in disclosure. And to me, that's the real heart of this kind of tension. Just my take on it. It's a tough one. If a federal agency, through its IG, I think that means Inspector General Office, asks for an arrest report of an employee, should that be considered an employer-related request or a law enforcement agency request for determining whether to release? Mary, I'm going to suggest that, I mean, that is a very specific question that I think is going to trigger other exemptions. Not necessarily on topic for today. If you have a specific question that you want to raise with us, if you would just reach out to us privately, we can take that up. I think that's going to have multiple dimensions that are other than what we're focused on today. So I don't mean to put you off. I invite you to contact us either by email or just give us a call. Okay. If we don't have any more chat questions, we have a couple of other sections we want to run through today. So if an agency decides that it is going to invoke the deliberative process or work product protections or any other exemption for that matter, you'll issue what's known as a letter that is denying the request, either in whole or in part. That's governed by Section 4203 of the Act. Again, you see the little icon in the lower right corner of the screen. That will take you right to the relevant portion of the manual. If you want to look at a sample, I think that's taking you to the sample denial letter. And your letter is going to include the reasons you're denying it. That generally is going to include citation to the legal authority for the denial and an explanation of what remedies the requester has in case they disagree or want to pursue it further. When we say the reasons for the denial, generally speaking, that should include a brief description of the material that's being withheld, and it should be enough to inform the requester about what about this record ties it to this exemption. And I would urge agencies, when you do this, to keep your audience in mind. Many times I get inquiries from requesters, and they get the legal citation, they get the name of the privilege, but what they don't get is what does that have to do with my request, or what does that have to do with this record? So, being clear, speaking in very plain terms, in ways that are likely to actually communicate is always best. And of course, in case of discretionary exemptions, you always want to be considering whether some portion of this document can be produced. And if you can't produce any part of it, you want to explain why. Sometimes there just will not be any non-privileged content, in which case you can't redact it, or it's just too inextricably intertwined, and therefore, again, redaction doesn't work. The remedies that are available under Maryland law currently include mediation through my office. If mediation doesn't resolve the problem, in some cases, there's an option to go to for the aggrieved party to go to the PIA Compliance Board. I say aggrieved party, not requester, because there are new provisions in the law that went into effect last July that allow agencies to bring complaints to the ombudsman and for relating to vexatious or bad faith or otherwise kind of beyond the pale. That's not the legal term of art. That's my take, beyond the pale types of requests. And if we don't work it out in mediation, they're eligible to go to the board too. And then last but not least, parties always have the option to go to court and to get a judge to rule on questions. So we can go to the next. Yep, remedies and enforcement. Those are the three basics: mediation, the board, or court. That's how we resolve PIA. We try to resolve PIA disputes in Maryland. I think most of you know that the hallmark of my process is it is entirely voluntary. Nobody need come to my office. For the board remedy, mediation, however, has to be attempted first. This is a change. Previously, you could go straight to the board with certain fee disputes. You can't do that anymore. You can go to the board with fee disputes if the amount is greater than $350, but you have to stop first at my office to see if we can work it out by agreement. And now, since July 1 of last year, the board also can hear matters that relate to denials of records. It still has jurisdiction over those same fee disputes. If an agency doesn't answer a request at all, that kind of a complaint, if we can't resolve that in mediation, can go to the board. And then the new provision that I just mentioned that relates to, and this is the language straight out of the statute, requests that are frivolous vexatious or in bad faith, agencies can bring those in for mediation, and if not resolved, onto the board. Judicial review, the right of judicial review is provided in section 4362. And of course, courts have a whole array of enforcement tools that are not available through not available through my office, not available through the board either. And that includes, in appropriate cases, award of costs and fees if successful. Here's a question, Sarah. Has the board made decisions regarding requests that are frivolous, vexation, or in bad faith?
No, we have not had a complaint under that section yet.
And I would chime in too, if I may, under the board's proactive disclosure policy, all matters that are pending with them or where decisions have been issued are posted on the board's website. So if you're ever wondering, might there be a vexatious or bad faith matter pending with the board, you can always check the website, and we keep that up to date. Normally within 24 hours, we have all new complaints and the information up there, as well as any decisions that have been issued.
And the next question is, has the ombudsman, I have a very strict confidentiality limitations, but I would simply say I've not had any agency initiated mediation focused on that. Meaning I haven't had a mediation that was where the initiating party was the agency and that was the agency's complaint. That's not to say that I haven't had mediations where those words didn't come up. So I hope that answers your question. Of course, in order to get to the board, it would have to come to mediation first, and no agency has initiated that type of complaint with me. Somebody got the reference. Yeah. Okay. All right. Yeah, remedies. So, as this is the part where I get to do my commercial for my office. I think it's basic. Even though I have no enforcement authority whatsoever, I think the real strengths of my program are that participation is voluntary. People who come to me do it hopefully because they want to reach a resolution. It is confidential. It is a safe space to candidly express views. And it also has the virtue of being very flexible. Parties can reach agreements to resolve a dispute that may not be provided for in the Act, and that gives us a great deal of flexibility. There's no subject matter limitation on our mediation program. Any kind of dispute whatsoever that comes up relating to a PIA request or a PIA response or a non-response or an incomplete response or a late response or a premature response or whatever problem it is, repetitive requests can be mediated. We can try to deal with any problem at all relating to a PIA request or response in mediation. And either, mediations can be initiated by a requester or by an agency or by both. And I think those are the basic kind of strengths that mediation has to offer in this context. So now we're going to get to the newsy part, just really some brief blurbs about what we are up to. So first, let's go to the legislative updates, and I'm going to ask Sarah if she'll cover that part.
Sure. So there were a good handful of PIA-related bills that got introduced this session, but there were only two that actually made it through and were enacted by the General Assembly. So the first one was House Bill 636, which relates to inspection of email addresses and telephone numbers. The bill changes the definition of personal information so that it includes personal email addresses. I think, as was pointed out during the session, the PIA was enacted many moons ago before email was, I think, even used, certainly, not used commonly. And so, there aren't very many sections that actually refer to email addresses. And so I think that that was sometimes a source of confusion and frustration amongst all parties. So the when this bill becomes effective in October, that custodians generally are going to be required to deny or redact out personal email addresses and telephone numbers. There are certain circumstances where that information, a personal email address or personal telephone number, may be disclosed, most specifically in the licensee context. So somebody who, a licensee who uses their personal email address as, for all intents and purposes, their business address, that may be disclosed because it's basically a business address. But otherwise, that will be information that has to be redacted. And then the second bill is House Bill 1051. This bill made small amendments to the appellate rights following a board decision. So it specifies that, I guess I should back up. So if someone takes a matter to the board will issue a decision, and then the aggrieved party, so say the board orders that a record be disclosed, the custodian could file a complaint to circuit court arguing that the board wrongly decided the matter. Or conversely, if the board upholds a record being withheld, the requester could go to circuit court, file an appeal, and argue that the record should be disclosed, that the board's decision was wrong. It was sort of unclear whether or not there were any further appellate rights beyond circuit court. So now the law will specify that once the circuit court rules on a board appeal, that the party aggrieved by the circuit court's decision will have the ability to appeal to the appellate court of Maryland. During session, that bill was also amended to clarify. So previously, and I should say currently, since this takes effect in October as well, the language of the statute allows a custodian or complainant to file an appeal from a board decision, but that would leave out scenarios where the board determines that a request is vexatious, right? Because in that circumstance, the custodian is the complainant, and arguably that language would leave a requester who has been deemed vexatious by the board without the ability to appeal. So that language was changed to include the word applicant, which would allow that applicant or PIA requester to appeal an adverse board decision in that specific context. And then I think there is a link in there that you can see all the bills that were tagged public information. That's actually going to turn up a whole lot of bills that are not necessarily PIA related. But if you have an interest in some of the bills that the General Assembly did consider that were related to the PIA, you could start there to sort of look through those pieces of legislation.
And as far as Ombudsman Office news, we are working on updating our regulations. We have some short and sweet regulations that were adopted in, I think, 2019. House Bill 183, which went into effect last July, has required us to make some tweaks to our program, including, for example, we now generally have to bring mediations to closure within 90 days of opening a file. We also have to issue something called a final determination when we close a file. That's a document that identifies the parties to the mediation, the issue that is mediated, and what its outcome in mediation is. That's a document that if either party wants to take an issue to the board, that final determination has to be provided to the board. And so we are basically tweaking our regulations and expanding them somewhat to address those changes to our process and operational changes that are necessitated by them. We circulated an early draft of these regulations late last year. I think in December. We got a few comments back that were very useful to us, actually. And we are about to begin the kind of more formal process in which there will be a formal notice and comment period. so stay tuned for that. I think Spencer's going to be talking about some things we're doing to kind of revamp and update and try to expand our training and outreach through our website and through other publications to include ways people can readily ask to be included on our mailing and notice list so that they can be sure they get notice of things that we're up to. But let me turn that over to Spencer, who is taking the lead on a lot of these things.
Surprise, now you get my mug, everybody. So thanks again for joining us. Just real quick to touch on the final 3 points on this slide. As you can see from this presentation, our Brown Bag Lunch Series, as we've dubbed it, is a new undertaking from the office. And certainly we are trying to cue in on those topics that are of most particular interest and importance, not only to our agency program users, but also our requesters. So if you have ideas about topics that you would like to see covered, we are more than happy to engage with you on those recommendations, and if possible, build another kind of training like this. Of course, we do still offer our PIA 101 training, which is kind of a 2 to 2.5 hour start to finish comprehensive look at the PIA itself. It does delve a little bit into what we covered today, on top of everything else that could be covered, including fees and what other exemptions may be applicable, how to access our program, the basics of the PIA, et cetera, et cetera. So please, if you have any ideas or anything that you want from us, you can always contact us. Our information is on the next slide. And if you or your group or your agency, because we have private citizen groups as well as agencies request training from us in a more private setting where we can have that frank discussion, reach out to us, let us know. It is just the 3 of us in the office, and we do the absolute best that we can with what we have. So we appreciate everybody's flexibility and understanding as we try to get folks on the schedule. But certainly we find that these opportunities to connect with folks prove incredibly beneficial and do help to curb the matters that are coming into the ombudsman and potentially the board. By way of the website, we are looking at completely overhauling it. For those that have been around the Maryland.gov network, you'll see that the state over the last year and a half or so has updated their branding standards. And meanwhile, Lisa's website is stuck 2 or 3 generations ago from before my time. So we're trying to work right now with Do It. They've been fantastic so far in identifying what we can do with our website to bring it to that next level, make it more user-friendly, more accessible to folks. We do have a lot of stuff on there that really is not of a lot of value to folks anymore. So we're looking to pare it down and really make our website as interactive and as beneficial to everybody as possible, but still inviting. Please contact our office, use our website. It's there as a resource. It's meant to help folks, and that's the ultimate lens that we're using when figuring out how to bring our website to the next level. And then the same thing goes with our publication. So we've talked internally with some of the new issues and hot topics like Anton's Law out there, what we can do with the Ombudsman's annual report and other various publications that we have to reflect those items of interest with our mediation documents that many folks that have joined us today have received. When a file has been opened, we're making sure that those are current and up to date. If they can be clear, if something needs to be corrected, we always welcome that kind of feedback. Certainly, they're again meant to help you. We know our process, we know the lingo, but we don't necessarily go into any interaction with folks contacting us and entering our program with the level of fluency that we have. We're here to help, and we really do take that resource for everybody to heart. So your feedback is crucial to making us successful. And I think that about covers everything.
Thanks, Spence. Yep. And that takes us to our thank you for coming. We look forward to working with you going forward, and you know how to get in touch with us. Follow us on Twitter and YouTube. We try to provide links and updates on anything having to do with the PIA. So if people have questions that we didn't address and you want to stay on the line, we'll hang out a bit and try to address your questions.